Okay, let's go through the purchase agreement. And I'm going to let you know that we're going to go through it. I'm going to teach you how to do the whole entire thing. But in the upcoming months, it's going to change because we never leave anything alone and we always mess with it. But it's for a good reason. So I have seen a copy of the new version. It's going to be terrific. I will train you on that, and it'll probably be on one of the broker Q&A calls where I will train you on the new contract. So the bulk of the clauses are going to stay exactly the same. So it's not like it's going to change dramatically. A couple of the clauses are going to change in a significant way, but 85% of the contract is going to stay exactly the same. So let's look at purchase agreement. And we're just going to go through it here. If you have a copy of it, that's okay. If you don't, that's okay too. The first section, would it be helpful if I emailed everybody a copy right now? That probably, I'm going over concepts here. I'm not necessarily reading it out loud to you. So you should be okay. But if you want to hop off, grab a copy, you're certainly welcome to. The top section of page 1 is going to simply be the description of the parties and the property. So we are indicating that the parties are made up of this person and these people and these people. I had to do an amendment last night to remove one of my sellers from a contract because it turns out they're not actually on the deed. I don't know why it didn't occur to them to tell me when I said, hey, do y'all both own the house? And they were like, we sure do. And then later, they do not. So it just simply took an amendment and we removed one of the parties. And I had to be like, sorry, you know, not trying to be mean, but can't sell a house you don't own. So we got one of the parties removed through an amendment. So ask the question when you're filling this out. Hey, are y'all both on the deed? If you're not both on the deed, let's talk about that for a second. You know, if the municipality website, if the GIS lists only one of the parties as the seller or as the owner, just ask the question, you know. And then section 1 talks about the real property. It is my preference for y'all in section 1, the best business practice is to have 3 separate descriptions of the property. So I would like to have, if available, lot, block, and section number. On the section called other description, I want the tax ID number or tax ID numbers. There may be more than one tax ID number. And then the or more commonly known as is the address. We did have an agent who will go unnamed. He's been retired and deceased for a long time now, but he did sell the wrong property one time. I know Jennifer remembers. He accidentally wrote the wrong address on there, the wrong street number on there. And somehow I got all the way through till title search. And not sure how. Now, listen, I'm going to defend myself here. How do I know what street address number? I have to trust you people are putting the right street address number on these purchase agreements. Okay. I will admit, I'm not going to Google Maps and looking and making sure it matches or go into MLS and making sure your addresses match. Right after that, I realized maybe I should be, but I'm not. So he actually sold the wrong house. So we had to do an amendment for him to not sell the neighbor's house. Be careful with things like boulevard, circle, court, okay? Thompson Ridge Road is different than Thompson Ridge Circle, which is different than Thompson Ridge Court, okay? Those are different streets. You're going to have to be careful about that, please. Print out the MLS sheet as the buyer's agent, but then also print out the CRS tax record so that you can cross-reference. I will never, ever in my career trust that the MLS data is accurate when I craft this legally binding purchase agreement, okay? I'm going to cross-reference it to the municipality website and make sure everybody keyed everything in correctly. Human error happens. The other best business practice I am always doing is before I send my buyer this document to sign, I'm sending them an email that says tax information. I am sending them a PDF of all of the information on the CRS tax data, which you can click a button and say save as PDF. And I'm also going to the actual municipality GIS system, and I am saving as a PDF that information as well. And then I am sending both of those documents to my buyer and saying, hey guys, as I'm prepping our purchase offer, would you please look through this tax documentation and make sure that nothing on there looks incorrect to you or is a deal breaker for you? The CRS tax data is even going to have the FEMA information on it. So there's going to be a lot of good information on there that I want my buyers to receive and look at. Now, I can't make them read it, but I can prove later that I sent it to them. Okay, moving on. That giant box in the middle of page 1 is the agency disclosure and confirmation, because it is important to know who is working for whom, okay? We're going to do the listing agent and the listing firm on the left-hand side, and we're going to click the box for the seller in both of those, unless this is designated agency. First, you know I don't want you doing dual agency. Dual agency is where you represent the buyer and the seller. Don't do it. Just don't do it. If I can create a successful career not doing dual agency, you can too. There is never going to be enough money for me to do dual agency. So designated agency, though, happens all the time. It just means 2 Wainwright agents are representing the buyer and the seller. So in that case, the listing agent is going to be Rhonda Ellis with the listing, with her representing just the seller, with the listing firm being Wainwright and Company Realtors. And then you're going to check the box for both the seller and the purchaser, because Wainwright and Company is representing both. And then over on the selling agent side, we're going to have Rita representing only the purchaser, but the selling firm is Wainwright and Company again, representing both the seller and the purchaser. Does that make sense? Great. Then we're going to have everybody sign it. Then we have our list of addenda. This is important. Don't reference per MLS anywhere in this document unless you have checked the box under addenda and included the MLS printout. It's fine to do that. I think it's probably a good business practice. Have both parties initial or sign the MLS printout, that they're acknowledging that that is the information they were told. Because in the private remarks, there might be a disclosure about water in the basement or something conveying an as-is condition. Now, you're probably going to have a fight if it's conveying an as-is condition, but you don't reiterate it in the additional terms on the actual purchase agreement. I want everything on the purchase agreement. The purchase agreement is it. I sold a house last year. It was a patio home. We did not include the outdoor television that was on the screen porch. And later, the buyer's agent came back and pitched a fit about this TV. Well, it's a $3,000 television because it is actually made to be outside. It is actually made to weather all sorts of weather and including snow. So it's a $3,000 television. I can tell you, they didn't write it in the contract. They're not getting it. I did not include it anywhere on the MLS sheet. I did not say it was conveying, and she did not put it on there. Unfortunately, she said that she was told at an open house that the television would convey. Not good enough, though. Ultimately, I told them, I can't make them give you this TV, but I'll go halves with you on buying them just a cheap TV from Walmart. It'll last them one season. That's all I'm willing to do. I will put a TV out there for them, but I'm not, I'm not buying them a $3,000 television because you didn't write it into the contract. Write it into the contract, okay? Don't put per MLS and attach the sheet. That's going to create arguments. Yes, you could probably defend that, but why do you want to go to that trouble when you could just write it on the personal property section? Okay, this is the difference between being able to defend yourself later or just using a best business practice up front. Yes, Rita.
I would just add too that there was a contract I wrote where the listing said the refrigerator didn't convey, but the buyer that I had wanted that refrigerator. So we wrote a full price offer back when things weren't going full price, but we did ask for that appliance and also the washer and dryer. And it got fully accepted. We're heading to closing. And the agent who was selling it said, hey, you know, they're taking that refrigerator with them. And I said, no, they're not.
Mhm.
She was so upset, but she had sent the contract over to her people. She did not read it to them. She didn't explain anything. She just said, this is a full price offer. Let's take it. And they signed it and sent it back. And so we had a $3,000 item. And then the listing agent called me and asked me to split the cost of buying a new one. And I said, no, ma'am. I read the contract to my people. That's what you should have done for your people, in my opinion.
Yes,
So
absolutely.
we got the refrigerator and I didn't pay for it. Why would I pay for it?
That's right. I assure you, well, I have paid for half of a pool heater somewhere in Roanoke. There are lots of things I own around town, but a lot of that has to do with either something is my omission, and in case of the pool heater, it was my omission. And then in other cases, it's not my fault. However, I paid $75 towards a TV to go on that back porch, and my husband and I went over and installed it. Some of that is just concierge care I'm giving to my seller, and it's by a case basis. I'm not telling you ever have to do that. And Rita's right. What is she supposed to do? Drive over there and read the contract to the sellers? Certainly
not. And I agree with you. There's plenty of things I've paid for.
Yeah.
But in this case, I just felt like this agent was taking the lazy way out.
Oh, yeah. Yeah.
And never said a word to us. Inspections and everything went past. And anyway.
I hear you. Oh, and the one with the TV, she was just irate that I wouldn't, quote unquote, honor what someone had told her at an open house. And I'm like, whew. I got a little book of people who I will say no thank you to if they ever come interview here, because I don't know that I can fix that attitude. Okay. So addenda. You also are going to have to include anything that is not, well, obviously X the boxes of the addenda you're going to include. But if there are others like subject to subject to sale contingency form, you're going to have to check the box there and type it in there. Okay. There are all sorts of addenda that can be included beyond. That's why there are blanks here. All right. Page 2. I want to explain to you why we disclose whether this will be an owner occupied home or not. This has to do with mortgages. Okay. It also has to do with the seller knowing the intentions of the purchaser. Whether the owner is going to occupy the home or not is part of the decision-making process when a seller is reviewing the contract. Okay. I have had situations where a seller has said, I don't want an investor buying my house. Well, I'm here to tell you, investor is not a protected class. So they can say that. They can say, I don't want an investor buying my house. That's absolutely fine. Now, if somebody decides to fill this out incorrectly and fib on this thing, I got no control over that. But you are supposed to indicate whether you're going to occupy or not occupy a home. I will warn you that if the investor is of a protected class, be careful about how you phrase that you're turning down the offer. Do not take an offer from another investor later. Okay. That is just good common sense. Don't say it's about the person being an investor when it's really not. Okay. And feel free to have a conversation with your sellers or any of your clients about discrimination and protected class statuses. If you're having any trouble, call me. I'm happy to chat with them about it. Mortgages care whether this is an owner occupant house or not, and you could be constituting mortgage fraud with your buyer if you say they intend to occupy the property when you know they aren't. So if this, and the number of times an investor has said to me, yeah, but I want the rate that an owner occupied mortgage is going to give me. Yeah, I get that. I do, but you're not an owner occupant. So you don't get that rate. You get a higher rate because you are an investor. And if you start to have money trouble, The home you live in, you're going to make sure you keep. And all those investment properties, you're going to let go belly up. So there is a reason why there are better rates for owner occupants. There's a reason why there are better rates for people bringing large down payments. You are a lower foreclosure risk. So you are a less risky applicant for a mortgage. So please, as a buyer's agent, ask the question, hey, are you guys going to occupy the home or not? And if they say, well, wink, wink, we're going to be an occupant. No, ask further questions. You do not want to be part of mortgage fraud. Okay. 4, residential property disclosure. Is this home or is this home not in a residential property disclosure required property? So I want you to make a note here. The exemptions to the Residential Property Disclosure Act are estate sales, foreclosures, new construction, and almost always investment properties. The reasoning is none of those owners have ever resided in the home. How can they make or not make disclosures about a property they've never lived in? So those are the exemptions to that. If in doubt, call me and we'll walk through whether it is a residential property disclosure required property or not. 5, property owners association disclosure. And again, guys, I'm glossing over a little bit of this just because we'll never fit it into an hour, but I'm going to go back to certain clauses like we did the property owners association section pretty intensely a couple of training sessions ago. So we will go in more depth into these clauses at other times. Number 5 is the property owners association disclosure. Is or is it not in a property owners association? I just was talking on the last call about my double wide I've been trying to get closed. Well, she was not a peach in any department because also there seemed to be a property owners association, but nobody knew who was in charge of it. No one's ever paid into it for years. Essentially, it's defunct. I ultimately never could get any information about it. And I went back to every listing that had ever happened in that subdivision and reached out to every one of those agents to say, hey, did you ever find a property owners association? First off, most of them couldn't even remember. But all of them had indicated no as property owners association. Ultimately, I just had to craft an email to the buyer's agent to say, hey, these are the steps I took to try to find out whether there is a property owners association still active or not. Dead end, dead end, dead end, dead end. I think it is safe for me to now disclose to you that I will not be providing you a property owners association packet. Consider this your notice that a packet is not available. And then that begins the counting on how many days they have to terminate or not. Okay. So the buyer still had a termination right because when they were made notice in writing that a packet was not forthcoming, that begins the counting for them to say, okay, I'm going to either terminate or not terminate. Okay. But it was important for me to go ahead and wrap that up. And I wanted to give it a true earnest effort so I could prove that I really did look. I didn't just go, oh, we don't know where it is. Okay, there isn't one. So I wanted to document in there what steps I'd taken to try to find and dig out a property owners association contact info. Same with condominium disclosure in number 6. Those are very similar sets of requirements and termination rights. And then 7, I want you to understand, these are the clauses that require no action on your part, but I want you to understand what they're saying. So mechanics lien disclosure. As a buyer's agent, I'm saying to my buyer, this is a clause indicating that if the seller has had any work performed or goods delivered to the property and they have not paid for them, then the vendor can place a lien on the property at the courthouse anytime 90 days following the last day of the month in which materials were delivered or work was performed for which they have not been paid. And buyer, you understand then that this lien may be placed on the property after you have taken ownership, and it will become your responsibility to satisfy it. It will become a lien attached to the property you now owe. And I understand that sounds unfair, So I'm here to assure you that the sellers are also going to be asked that question at closing. So I feel like you could take them to small claims court successfully after the fact. Also, this doesn't happen terribly often. But if I am a buyer's agent and we're in there and I'm having this conversation with them as we're writing the offer, I'm going to say to them, did you guys see anything that looked to be brand spanking new? And if they go, well, that deck is fresh, I may shoot off an email to the listing agent to say, hey, can you confirm for me that the deck has been paid in full? All of that is just supporting evidence for later if a problem happens later. Okay. I get it. Lord, our job is about 900 tasks. I do. And it seems like there is a never ending list of what we're responsible for. But so much of this is the trust you're building with your client, where they feel like you're always on top of it, you know, and even if a problem arises later, you have protected their interest early on to make sure that nothing's going to bite them in the rear end later. Okay. Jennifer, did you have something to add?
Just a question. So let's say that does happen and you have a mechanic's lien placed for the deck. Is that something that the title insurance would then handle on your behalf and go after that seller for that
It
payment?
certainly could. And that is going to be the first thing I recommend to you when you call me and say, Ashley, my buyers called me and there's a lien on their property. They just got notice of it. The first thing we're going to do is we're going to say, did they get title insurance? And y'all, your buyers need to get title insurance without fail. The only reason why I would ever say they don't need it is if they're buying their family farm that's been in their family for 100 generations. Okay. But even then you might have a cousin come back and say, I was one of the heirs and I didn't sign anything. Okay. Get title insurance. The buyers are going to have to buy it on behalf of the mortgage company to protect the mortgage company, but they really need to be purchasing a buyer's, an owner's policy as well, which will protect them, the owners. Excellent point, Jennifer. All right. 8, fair housing disclosure. This is what I say to my buyers. I say, buyers, this is the fair housing disclosure. This is just stating that I am not discriminating against you or the other party for any of the protected class reasons. That's all I say. Okay. I then also say in section 9, this is Megan's Law disclosure. I urge you, the buyer, to do your own research regarding Megan's Law. Here is the phone number or the website. It will be your responsibility to search the registered sex offender registry to satisfy yourselves that you would like to purchase this property. I cannot do this for you. Okay? Do not do it for them. Ever. Okay? I don't even care if they're sitting with you at your laptop and you'll do it together. Don't do it. If you want to pause and say, would you like to go call real quick and check? Or would you like to get on your phone and go to this website and check? We certainly can take a pause and give you an opportunity to do that. And then I say to them, if we make a discovery after we're under contract that changes your mind due to Megan's Law, it is not a termination right. We will not be allowed to terminate this contract. So this is a now or never research item. Okay? Just to get real heavy in the middle of the exciting contract writing. 10, fixtures and personal property included. Y'all don't put per MLS. I will whip you. Okay? That always bites people in the rear end. Any listing agent can go on there and change the MLS. Okay? Why do you want to fight on the back end when you could just do your job in the front end? Okay. We're going to list, in my opinion, even the things that are in that standard language. If my people want the curtains, I'm writing the curtains on that line. I know it's in the standard language. Also, help your sellers understand from the get-go, that chandelier in the dining room, unless we say it is not conveying, and we indicated on here that it is not conveying, the buyers are getting that chandelier. Rita's refrigerator is a perfect example. The listing agent didn't even include it, but when the contract came, including the refrigerator or including the chandelier or including the dog, yes, that has happened. That was one of my dad's transactions. The new buyer got 2 dogs with the deal. If we're not including it on there, it is not going to happen. Okay. So even the stuff that is already written in the standard language, I'm writing it in. And more importantly, as a listing agent, I'm telling my sellers, take the chandelier down, stick that thing in the garage and put up a $10 Lowe's light before we go on the market. Okay. Because if they think they're getting the chandelier because it's a fixture and you forget to take it out of the language, or you forget to write chandelier does not convey, there's going to be a problem. Okay. So one of the things I ask in a listing appointment when we're prepping the house is I say, is there anything in here that is attached to the property? Let's go room by room and just take a quick glimpse. Anything attached to the property that you are not having convey? Are you taking the wine cooler? Are you taking the chandelier? Those curtains that match your bedspread, are you taking those with you? Ask. And if they say, oh yeah, that matches our bedspread, we're taking those curtains, then take them down. Take them down, pack them up now. But it'll show so much better with the curtains. I understand. I really do. Then we're going to have to remind each other that we're going to be writing bedroom curtains do not convey on the purchase agreement. Okay. Can you help me remember to do that? Because y'all, I'm not good about that. I'm not good about remembering that when the purchase offer comes in. Okay. Purchase price. We're going to obviously write in the purchase price there. And then we're going to get to deposit. Y'all, if anything keeps me awake at night, it's this clause right here. You are indicating on here how much the earnest money deposit is, who is holding it, what form of payment it is. Don't bring me cash, okay? Cash cannot be sourced. Cash is useless because the lender is not going to accept it later. And we're just going to have to dispose of it during the transaction with an amendment. And then the seller has no protection. The buyer has no skin in the game. So if you are a listing agent and you find out the earnest money was cash, I would probably be insisting that that gets replaced with a cashier's check from their bank so it can be sourced later. Okay. As a firm, we're not accepting cash. And I get it. People don't have checkbooks anymore. So what you do is you send your buyer to the bank, their bank. They need to get a cashier's check made at their bank with funds they are pulling right that minute from their own account. Don't go to the bank with $1,000 from under the mattress or in the liquor cabinet and go get a cashier's check. No one can source those funds. The lender is going to refuse that earnest money later. So tell them the process. Hey, do you have a checkbook? Can you write me a check? Oh no, we haven't had a checkbook for years. Okay, well, here's what I need you to do. I need you to go to your bank, transfer money out of your account, and have them cut a cashier's check for $500 made out to Wainwright and Company. Okay, does that make sense? Y'all, I start these calls and I think I won't have that much to say. And then all of a sudden I'm like, how am I going to get it all done? Okay, so now we're going to check the box for purchaser has paid or purchaser shall deliver. Shall deliver does not mean that's how many numbers of days they have to get it in the mail. We have to have it. Okay. We have to have it within 5 business days. Okay. It is your job as the buyer's agent. If you say has paid, that check better be in your hand because you're saying it's in your hand. I almost always recommend the shall deliver so that you've got a second to get your thoughts about you and get the check from them. It is not the buyer's job to remember to bring it to you. It's your job to remind them to bring it to you. Okay. And remind them when you're writing this contract and you fill that out, I want you to pause, either schedule an email or put a notification on your phone to ask for it the very next day. Because I'm here to tell you, I'm one of those who 2 days later, I'm like, oh man, I completely forgot to remind them to bring me the earnest money. I'm still celebrating we got the house under contract, right? And I forget to go ask for that earnest money. Well, they've forgotten too. It's going to be your fault. It's going to be my fault. I'm going to have to turn you into the Virginia Real Estate Board. I don't want to do that, y'all. So set a reminder in your phone that within 24 hours, you're going to call your buyer and say, hey, where can I meet you to get your earnest money check? These are those little processes that will help you not let things fall through the cracks. And then there's a large paragraph about how that is going to happen and how those funds can be released later. We'll get into that a little deeper later. I've just told you the most critical parts of your part of the job that need to happen. So now we get into financing. Lender's first trust is the mortgage. Are we going to have a mortgage? I expect you to fully fill out this information, but do not guess. You should have a relationship with the lender where you can call them or you can email them and say, hey, can you send me a pre-qualification letter? And will you indicate the type of loan, the interest rate, all of that on the letter so that I can fill out the financing portion of our purchase offer we're about to make? If that is not included on their pre-qualification letter, that's okay, but you need to ask the lender, what interest rate are we doing? What size down payment are they bringing? Because I want you to fill all that in because it's important to the seller in making their decision. And what you fill in here is what the buyer is going to have to do. So make sure you're careful about and deliberate about what you're putting in these blanks. So you're going to pick the loan type. And then you're going to put in the principal amount of. That's the loan amount. The principal amount is what are they actually going to be financing? If it's a $200,000 purchase and they're bringing a $40,000 down payment, then your loan amount there is $160,000. Now, if you've put down a $1,000 earnest money deposit, you may put $159,000 as the loan amount because they've already prepaid $1,000. But maybe they're going to use that for closing costs. So I think it's a safe bet to say the loan amount right there. Whatever the lender tells you is going to be the loan amount, that's what you're putting in that blank. Amortized over a term of 30 years, 20 years, 15 years, it just depends. Again, you should not be guessing. You are not the lender. You do not know. Confirm, even if the sellers are, even if the buyers are telling you what they're doing, confirm with the lender, okay? Now, I almost always pick at a fixed rate, not exceeding blank percent per year. I don't usually hit at the prevailing rate of interest at the time of settlement, and I'll tell you why. I want to preserve a termination right for my buyer that's associated with the rate. It's just an extra layer of protection I'm building into this contract. And I'm asking them what rate they are being quoted by their lender, and that's the rate I'm putting in there. Maybe I'm going 0.25% higher and saying, okay, the lender's going to give you 3%. Let's put 3.25% in there. Buyer, what that means is even if interest rates rise to 3.25%, you are still going to be obligated to purchase this home. Is that fine with you? And they'll usually say yes. Now, if I want to hedge my bets, I may put 3.0 in there and not increase it at all, not build a buffer in there. Because then if the interest rate goes higher, my buyer has a termination right. They don't have to terminate, but they could. If now the interest rate is 3.25% and I've said not exceeding 3%, my buyers have a termination right. So some of that is just the chess strategy involved in real estate where I'm hoping everything goes fine, but I'm trying to build in a few protections for my buyer in case things don't go fine. And then I'm probably not going to put a loan discount point in there. I'm never going to put more than one loan discount point in there because let me explain that to you. If I've said the buyer will accept up to 3.25% with no more than one loan discount point, then the rate could actually be higher than 3.25%. So long as a 1% discount point, meaning prepaid interest my buyer will be required to pay, would bring it back down to 3.25%. So when you put in a loan discount point there, that actually raises the interest rate that your buyer would have to accept. And they'd have to pay prepaid interest in the form of a loan discount point to buy it down, but you've said they would. So this is another example of where for 10 years, I'm writing in loan discount points and I didn't even know what they were, okay? So I didn't understand yet the implications of that and how I might be undercutting my buyer's ability to terminate if the interest rate isn't where they want it to be and where what they've said they'll accept. Okay. So I'm either putting 0 or 1 loan discount point in there. I don't think there's any reason to put in a loan discount point because your buyer can always elect to buy a loan discount point. The seller's never going to say, no, I'm not going to allow you to buy down your rate. Okay. The buyer always can buy down their rate with prepaid interest. But what we're saying here would actually possibly harm the buyer's ability to terminate if the interest rate goes up. I know y'all should have had 2 coffees this morning. I hear you. This is some tough stuff. Okay. Please don't click the box for at the prevailing rate. Unless your buyers have said, listen, this is right next door to my parents. I'm buying this house come hell or high water. I don't care what happens. I have to have this house. Fine. Click at the prevailing rate of interest. Okay. It would strengthen your offer because the seller would say, oh, cool. Doesn't matter what happens to interest rates. They're buying this house. Just, I want you to understand why you're checking the boxes you're checking and what it will mean for your buyer or what it would mean for the seller. Other deposit financing, I'm so sorry. Third party second trust, that would be if there's going to be a second mortgage. We're not in that market. We're not in that phase of lending products. So I would be very surprised to ever see anything filled out there. It may be a private loan. That may be a situation. But again, if it's something funky, call me and we'll work our way through it. Other deposit financing terms. This is where I'm going to encourage you to use our standard language. It's in the broker clauses on zip forms. Again, if you go to YouTube and go to our channel, there's going to be a quick tutorial on there showing you how to access the broker clauses. And I already have a broker clause written in there for some of the items you may write in here. Might be an appraisal contingency, might be a we wish to change financing terms contingency. I will tell you, I've seen that language change during this market. It has gone from seller and purchaser agree the purchaser may change the above financing so long as it does not affect seller's net or closing date to be, or change they may change the terms of the loan, but not the style of the loan. Meaning the seller is saying, no, you said conventional. We're not going to FHA. So I have seen that language change some. So call me if you need help with that. E, very, very important here. This is the one that bites buyers in the rear end. This says balance of the purchase price to be paid by purchaser in cash, cashier's check, certified check, or wire transfer funds at settlement. That is the one that is going to bite your buyer if they're doing a conventional loan and you have not written in a conventional loan appraisal clause contingency. Okay. If you're doing a conventional loan, you are going to need to write in an appraisal contingency. If you don't, this clause is what says your buyer better show up with the money or else. All right, cash contract. Y'all, I thought back in the day I would have a lot more of these. I do not. So I'm apparently mixing and mingling with the wrong types of people. But all my people need mortgages. So we are always filling out that upper portion. Cash contract does exist. You're going to put in here how many business days. I typically put in 5 business days from the date the contract is executed for the buyer to present proof of funds. Proof of funds can be a letter from their banker, a letter from their asset manager, a letter from their financial advisor, indicating that they have the funds liquid and readily accessible in order to close on the property. I have seen in instances, it's just a bank statement. Some sort of proof that the funds are available. Okay. Loan application. We're going to indicate here how many business days our buyer has to apply for the loan. I never put more than 5 days unless they're like, Ashley, we're going on a cruise tomorrow morning. Well, then I'm going to obviously explain that to the listing agent that they're going on a cruise for 5 days. I'm going to put 7 business days there because they're going to have to do it when they get back. Okay. And then the blank in the middle of that clause. Yeah.
I'm so sorry, I'm interrupting you.
Oh, you're fine.
The cash clause, if you go back up to that one for one more time.
Yeah.
So my seller is gonna pay cash, but it's proceeds from the sale of his house.
Oh yeah. And
How
this
do
is
you handle
happening
that?
some. So if you have said it's a cash contract and you have 5 days to provide proof of funds, but you've not made that contract subject to the consummation of their house they have under contract, you've just written a cash contract and they're going to be in breach of contract if that house falls through. So please be careful. Ask your buyers where their cash is coming from. If they say, oh yeah, it's going to be a cash contract, great. We're going to need to document where the cash is coming from. Where's the cash coming from? Oh, well, I'll have it when my property in Illinois closes. Oh, okay. Well, we're going to need to do a subject to consummation form and indicate in the additional financing terms that the cash at closing will be from the proceeds of the sale at 111 Main Street, in Illinois. Okay. Call me if the cash is something other than cash money in a bank, and we will craft that language together. Okay. Excellent point, Jennifer. Glad you're on the call. Okay. Loan application, that middle blank there. My rule of thumb, this is just my style of how I do it. I'm going to give my buyer until about 4 days prior to closing. So if my closing date is 30 days away, I'm going to look at what my settlement date is that I'm putting in there. I'm going to back it up 3 days, and that's going to be my date by which we're going to try to apply for the loan and get approved. Now, if I'm the listing agent, that may be a little too long. I may only want it to be 2 weeks. If you can't get approved for the loan within 2 weeks, are you going to get approved for the loan? So depends on which side of the transaction you're sitting on as to what you want to see in that blank. Okay. Moving on to the next page. It is just the second half of the loan application paragraph, because it's talking about lender required repairs. Lender required repairs come from the appraisal. Usually that has nothing to do with the conventional loan. And I'll say that to my buyers. If they're doing conventional, I'll typically say, you know what? I'll tell you what this clause means, but we're probably not going to have to fiddle with it because you're doing a conventional loan and the appraisers are really just looking for the value of the home. They're not typically using a checklist of what's the condition of the property. So if my buyer's doing FHA, VA, VHDA, USDA, did I say FHA? FHA. Then this clause is going to be very important because the appraiser is going to be having a checklist with them about, is there any peeling, chipping paint on the exterior of the home? What is the age of the home? So could that be lead-based paint chips? Are there any windows that are fully broken? Is there a handrail going down the basement stairs?
I'm going to chime in there.
Please.
I just was with my appraiser friend last night, and she asked if we are seeing the hot water pop-off valve
PVC
pipe
valve?
that's supposed to be down the thing. FHA is knocking that now and making that a required repair. So she's had 2 this week.
So that is essentially an overflow valve. And they used to just be mounted on the side of the hot water heater with a valve, and it's a pressure relief valve. And hot water could spew out of it, okay? But you can install a PVC pipe, a little elbow, and a PVC pipe takes it all the way down to the ground within 6 inches of the ground. That way, when it does pressure relief, activate and hot water is going to be spewing out of the hot water heater, it's going to be directed down to the ground.
That's going to be in your face.
Not in your face. Exactly. So it's not a bad idea, but
So
if
that
you-
is an
that's
FHA
now
required
gonna
repair
start
now.
coming up. Okay.
Yep.
Good to know. Good to know. Keep her as a friend. Keep buying her a margarita every once in a while.
Oh, yes.
So this clause is saying that there may be repairs that come up associated with the appraisal, and that they're going to have to be completed prior to closing as a condition of the loan. The appraiser is going to have to come back out and see that they've been completed. But this clause, very importantly, is saying that the seller is not obligated to make these repairs, but they can't keep the buyer from doing it. So if there is a TVP valve that needs to be extended down to the floor to within 6 inches of the floor, the seller doesn't have to do that repair, but they have to let the buyer hire a plumber to come in and do that prior to closing. Okay? You can't prevent the buyer from addressing the lender required repairs that come up during the appraisal. All right. This next section, the purchaser shall be in default if settlement does not occur because of, and I say to my buyers, y'all, this is the sabotage clause. If you want out of the contract, you call me. Don't do anything that you think will get you out of the contract. Talk to me about it first. I'm your agent. I work for you. I don't work for the seller. If it's in your best interest to terminate this contract, or you tell me that's what you want to do, we're going to walk our way through it the right way. These are ways in which, buyer, you could be in default and get sued if you do any of these. And it's failed to apply for the loan in the same terms set forth above. So if they don't apply for the loan, and sometimes this happens as a listing agent, they may reach out to me and go, hey, Ashley, yesterday was the last day for the buyer to apply for the loan. Can you please confirm for me that they did? Well, if they didn't apply and they go, oh, Ashley, I'm sorry, we were really busy at work, that seller can terminate the contract. So please make sure your buyers understand it's important they work within the timelines that we are indicating on here. Fail to lock in the interest rate so that it goes above the interest rate that's acceptable. They can't just never lock in the rate, okay? That could be a reason they would be in breach of contract. Fail to comply with the lender's requirements in a timely manner. Do not have the funds to settle as provided. That's the one that's going to bite them in the rear end if they're doing a conventional loan and you've not written in an appraisal contingency. So if they don't have the funds to settle, they are in breach of contract. It's spelled out right here. Fail to notify the lender, seller, or listing firm promptly of any material adverse change that will prevent them from obtaining financing. That's quitting your job, taking out a new 0% interest rate credit card at the furniture store, buying a car. Y'all, I had one die on the vine because she took out a line of credit to buy Christmas with. Well, and she tried to tell me like, well, don't my kids deserve a nice Christmas? Well, yes, but they will be having it in your apartment because you cannot buy a house. Now, of course, I did not say that to her, but that is what I wanted to say. You know, anytime you need to counsel your buyers. Anytime they're making a purchase and the cashier says, hey, have you thought about getting a line of credit with our store? You know, it'll be 0% financing, or you get three free pairs of socks, whatever it is they're giving you as an incentive to sign you up for the store credit card, just say no. Just say no. And I had that situation happen to me at Crate and Barrel. And she just kept going on and on about, yeah, but you'd save 25% on this purchase today. Yes, I understand, but I am currently refinancing my home. I would not like your store credit card. Thank you. You know, you have to understand how all these things will affect. That store employee has no idea that if I take out this credit card, I may tank my ability to refinance my home. Okay. Nor is it her job to know that. So make sure you're counseling your buyers about their credit. Do any act or fail to do any act that would keep them from obtaining financing. Again, that's quitting your job, buying a car, make any knowingly false representations. Okay. You can't lie about your income. You gotta tell the truth. Okay. 14, and I know we're almost out of time, y'all. Just stick with me if you can. If you got to leave, I totally understand. 14 says, is it or is it not contingent upon inspections? If it's contingent upon inspections, we're going to have the inspection addendum. And if it is contingent upon inspections, 15A is going to apply. 15A says that you're also allowed to have a walkthrough 5 days prior to settlement or occupancy, whichever occurs first. And the purpose of the walkthrough is only to verify that the home is in the same condition, minus normal wear and tear, of when you saw the home and put the home under contract. If there is now a hole in the wall because the mover stuck a hole in the wall, the seller has to fix that. But if you spot something during the walkthrough that you should have spotted during the home inspection or the inspection phase and you didn't, and you could have spotted it, you may not have another bite at the apple. That inspection period has passed. Now, if there's a tree on the house, if there's a hole in the wall that wasn't there, if there's now water in the basement and there wasn't water in the basement any of the times you visited it prior, that would be, you'd be allowed as the buyer to go back on the seller and say, hey, we didn't know there was water in the basement. Okay. 15B basically says exactly the same thing, except it's if you are not making the contract contingent upon inspections, if you're buying the property in as is condition with no inspections. 15C states that the seller is going to allow access for all of these inspections, and the seller is going to keep all utilities on and everything in working order so that inspections and the walkthrough can take place properly. 15D states that unless the parties agree in writing, and this would be on the removal of contingency form, all of the repairs will have to be conducted by a licensed contractor or specialist in their field. Okay. 16 is simply an indication as to whether the home was built prior to 1978 or after 1978. And 17 is the sellers and purchasers options, which we have covered a million gazillion times because it is really the meat and potatoes of the renegotiations 2 weeks into the contract. And it simply says, what are the seller's obligations going to be in regards to material defects that are discovered? And then what choices will the buyer have? So, the seller's going to have two choices: fix everything at their own expense prior to closing, or credit the repair remediation limit, which is indicated here, the remediation limit. And if they choose to credit the remediation limit, the buyer then has two choices: accept the property in as-is condition and accept the credit at closing, or terminate the contract, receive a full refund of earnest money deposit, and not be deemed in default. If your intention is to put $1,000, put $1,000 in that slot. I know that bold line down there says that it will default to $1,000 if nothing's in there. But y'all, this new section had only been rolled out like a week when we had somebody at another firm sneak in $1,500 after it was all ratified. And that was now the new version of the contract. And then we had an argument. Okay. So put $1,000 in there if you mean $1,000. There's no reason to leave that blank. That's just being lazy. 18, default. This is how I explain to my buyers. If either you or if anybody in here defaults, the other parties may sue them. That could include real estate firms who may sue for commissions. 19, choice of settlement agent. This is in bold for a reason. This is very important. Everybody gets to pick their own settlement agent. We're not allowed to tell our people where they have to close. Now, it is not against the law for sellers or buyers to incentivize the other party to use the same settlement company. They can say, hey, I'll pay your closing costs for you, seller, if you close at our company, at our settlement company. They can do that. They just can't require it. Okay. Settlements. 20 is title insurance disclosure. Again, have your buyers and sellers have title insurance. And Miki, did you have a question?
Yes, I do. Back to the home inspection portion of it and the walkthrough. I am representing the buyer. And we are at limit basically with getting the repairs done. They signed the removal of contingency to have everything done by close, and we're supposed to close on Monday. He said everything should be done by the agent. The listing agent said everything should be done by this Friday, tomorrow. So obviously that's pushing our walkthrough very close to closing date.
Yeah, that's hard. You want to have enough time to respond to anything that may be wrong, but
Right.
also, Miki, you want it close enough that the movers have done all the damage they're going to do.
Right.
It's very hard to get a perfectly timed walkthrough.
So my next question is, how do you know, because I know it's supposed to be a licensed contractor, how do you know that those repairs were done by a licensed contractor?
So you should be getting receipts as the buyer's agent for everything. And if
Okay,
there is no contractor letterhead on that receipt, you need to ask the listing agent, hey, can you see if you can get that on letterhead? Hey, can you
Okay.
please share with me who did the work? Can I have
Okay.
their license number? And look it up. Because what happens is sometimes it's not. Sometimes after pushing and pushing and pushing, you find out the seller went ahead and did that electrical wiring.
Mhm.
Well, I'm not thrilled with that as the buyer's agent, but I can't go back in time and have them not do it. Okay. But what I can do is I can pitch a fit and tell them they need to get an electrician over there who will sign off on the work.
Okay. Okay, so he should be providing me with the receipt. Is that
Correct.
something I'm going to need to request?
Yes.
Probably. Okay.
They're supposed to provide receipts. But I want them earlier usually than they're providing them. So usually I'm asking for them.
Okay.
Yeah.
All right. Thank you.
You're very welcome. Okay, settlement and title insurance disclosure. Get title insurance. Have your buyer get an owner's policy as well. Those are usually sold by the settlement company. They certainly can shop around if they want to, just for the title insurance policies. But I found the policies are all fairly similar. So I usually do not have a problem with them buying the title insurance that whatever settlement company happens to be selling. title companies, settlement companies, closing offices, those are all the same term for the same organization. They typically have some sort of ownership interest in a title company, but they're not writing these policies. They're just like any sort of insurance agent, you know, they're just selling these policies that are available. So settlement is number 21. We're going to say where settlement's going to occur and on what date. Okay. This is a really critical piece after that. It says possession of the property shall be given at settlement unless otherwise agreed in writing by the parties. That is why you are allowed to hand the keys to your buyer as soon as they finish signing, not after recordation. And I will fight that tooth and nail forever. And you will have instances, and we have it pop up several times a year, where the seller says, no, I forbid you to release those keys, buyer's agent, until it records at the courthouse. No, I'm going to give the keys, and I'm going to let the listing agent know. I'm going to say, absolutely not. I'm handing over the keys. The contract is clear that I have the right to give them those keys. I'm going to give them possession at settlement. It does not say ownership happens at settlement. It says possession takes place at settlement. Ownership is when recordation happens at the courthouse. And you'll see some private remarks floating around on the MLS that says keys to be given after recordation. Well, what did we just learn about what it says on the MLS? That has no bearing unless it's in this purchase agreement. So if you as the listing agent know your seller does not want the keys delivered until recordation, you better be writing that into the purchase agreement, okay? Otherwise, that buyer's agent is going to give the keys as soon as settlement is over, okay? Yes, Jennifer.
We had an instance where recording was delayed on a property. And I believe the sellers may have gotten cold feet. And the attorney advised that when the seller signed the deed, that is transferring ownership of the property. So you're doing that at the settlement office. Recording at the courthouse is only putting it on record of who the new owner is. When that deed is signed, you've transferred that property. It's not your property anymore.
That's right.
So just a little tidbit there, because we do see that a lot, that you're not getting the keys until it's recorded. Nah, sorry.
Nope. Not unless it's in writing on this purchase agreement.
Correct.
Yep. And I have to fight that fight 3 or 4 times a year through another broker who I know knows the same thing, but is having to try to support their seller by saying, okay, well, I'll tell them, you know, but I can't control what they do, you know. Okay. Last couple of items on here. Brokerage fee. That used to have a fill in the blank until sellers and buyers were like, cool, that's up for negotiations too. We get to put what we want in that blank. No, you do not. It is what is on the listing agreement between the seller and the listing agent. Until the Department of Justice tells us we have to be paid differently, which is probably coming down at some point, then it's whatever's in that listing agreement. That is what it is. And so this is what this standard language says. Do not ever, under any circumstances, try to renegotiate commission being offered to you. It is a realtor code of ethics violation, because you are saying as the buyer's agent, hey, listing agent, I know you have a legally binding agreement with your seller as to what will be paid, but I, a third party, am saying, how about we renegotiate that? It is a code of ethics violation. You cannot renegotiate other people's commission. It's also why listing agent, buyer's agent, neither one of you should be saying, like when the TV thing happened and I said I'd go halves on a TV, what I said was, listen, I'm going to pay for a TV on the back deck. I'm going to tell you, the cheapest TV I can find. It's going to be the same size. It is not going to be the same TV, but I'm going to buy the cheapest TV I can find that is a 60-inch TV. And that's going to be my gift to your clients when they close. You're welcome. She came back and said, I'll pay half on that TV. You can't say, I'll pay half on a TV. That's fine. You're not asking the other agent to pay half. But do not say, I'll pay half if you'll pay half. Don't say that, okay? You control what you do. Do not try to control what the other party does. And there have been plenty of times where I have said, I'll step up and I'll pay the $650 for the chimney flashing when I know there's another $500 fee for something else. And I'm hoping the other agent says, oh, Ashley, I'll take care of that. But they don't have to. You don't know what they've negotiated. Maybe they're getting paid 1% on it. You don't know what's happening on the other side of the transaction. So again, control what you do. Don't try to control what the other party's doing. Okay, last little bit. Assignability. This is where the buyer is indicating the contract may or may not be assignable. So what I say to my buyers is, buyers, do you plan on taking title to this property? Are you going to be on the deed as Joe and Phil Smith? Is that how y'all are going to be when we record the deed? If so, I'm going to say may not be assigned. Assigned means I know I've said Joe and Bob are buying it, but now 123 Main Street LLC is how they'd like to take title. Well, then that needs to be assignable. 123 Main Street LLC cannot take title to the property. They're not a buyer on this contract. Okay. So I asked them, how are you going to take title to it? Well, we actually might set up a trust and put it in a trust. Okay, well then let's make it assignable. And then I'm going to make sure I explain to my listing agent why I'm making it assignable. It's going to be important for them to know, because wholesaling is a real estate style of transaction where someone puts a house under contract, an investor type, puts a house under contract with a 60, 90-day close and then hunts around for a new buyer. And then they assign their rights to the contract to the new buyer for a fee. I do not want the listing agent to think my buyer is a wholesaler, because then the seller might go, I don't want a wholesaler buying my house. I want an owner occupant buying my house. So if I am ever indicating that this may be assignable, I'm going to make sure I explain to the listing agent why I'm making it assignable. Okay. Faxes are the same as originals. Attorney's fees. If a dispute breaks out, then the prevailing party may have their reasonable attorney's fees reimbursed to them. Home warranty program, by default, unless I'm making a crazy strong offer for my buyer, I'm usually declining, having my buyers decline a home warranty. And what I say to them is, listen, this is on here as a protection so that you know you were offered one. And that's really why it's on here. So let's talk more later about a home warranty, but let's not make it part of this transaction. You can elect to buy a home warranty program buyer anytime prior to closing, or even up until closing. So let's have that conversation off of this contract. Let's not make that the seller's responsibility. Unless I'm offering some stinking stellar deal here, and I think the seller should buy me a home warranty program. Or unless I've decided, my buyer has decided to buy the house with no inspections, but would like to have a home warranty provided for them instead. That can happen too, okay? And then there's the additional terms section. This is where you're going to want to write in that you are related to the purchaser, or some sort of weirdness that needs to be detailed on here, okay? Now, I'm going to go through the standard provisions page very quickly. I'm going to go through it as if you are my buyer. So this is how I literally explain this entire page to my buyer. I say, okay, buyer, this is the page of definitions and additional things we need to know. Expenses and prorations. If there is propane left in the tank, buyer, you're going to be expected to pay for that propane. The seller will be responsible for getting a measurement on how much is remaining in the tank at closing, or as close to closing as we can get it. And buyer, you're going to be prorated. You're going to have to pay the prorated amount of gas that is still in that tank. That is also true for any prorated taxes. If we're closing on December 15th, the seller has paid the property taxes usually all the way through the end of the year. You are now, buyer, at closing going to pay for December 15th through December 31st, because the seller isn't going to own the property during that time. So we have to pay the seller back for the taxes they've already paid. Land use assessment. There is a special tax incentive for land that has been considered in land use assessment. It's a qualification you have to apply for. This home is not that. You're not raising alpacas. We're not doing land use assessment in this property. Risk of loss. A tree could fall on the house prior to closing. If the seller owns the house, the seller is responsible for taking care of the property. And if they do not take care of it, we will have some termination rights. Okay. Title, the seller must convey clear title to you. However, if a title cloud comes up, the tail end of this clause is explaining that if a title cloud comes up, we, the buyers, are guaranteeing that we will give the seller 30 days from discovery of the title cloud to remedy the title cloud. If they cannot if they cannot cure the title defect or the title cloud within 30 days, the buyer has a termination right. But we have to give them 30 days to clear it up. E, equipment condition at settlement. Buyer, this is saying that the equipment is going to be in as is condition at closing, but it should be in working order, or it should be the way we agreed it would be. That's why we're going to have the walkthrough to verify. Certificates, if the seller has any certificates, perhaps for their new roof or their new furnace, or warranties of any type, they're going to be able to convey those to us if they wish. Miscellaneous, this is stating that this is the entire agreement. If we don't write in the chandelier on here, we're not getting the chandelier. So this is the whole agreement. It doesn't matter what they told us. It doesn't matter what we heard at an open house. What is on this contract is what matters. And then I'm going to explain, okay, buyers, let's go through some definitions. Purchaser's closing costs. I noticed that we had asked for closing costs. This is a list of the things that closing cost money that the seller is going to pay for us can apply towards. This is a great protection for us that I only really need to say closing costs, prepaids, points, and buy down points, because closing costs includes all of these things, including appraisal inspection fees, recording fees, title insurance premiums, all of that. That all can be closing costs. This is a list of everything that the closing cost money can be spent on. Purchaser's prepaid costs. Again, this is going to indicate what it is and that money can be used for that purpose. Same with discount points, buy down points, and discount points. Change the interest rate. They are prepaid interest. And then it explains what a business day is. Business days are weekdays in which the majority of the banks in the Roanoke Valley are open. And the business days begin counting the day after, the first business day after whatever act happened. So if we execute this contract today, our timeline for the inspection phase begins tomorrow, because tomorrow is a business day. If this were a Friday or a Saturday or a Sunday that we were executing it, it would be the very next business day would be day one when we begin counting. Rhonda, do you have a question? Okay, last two little bits. Thank you guys for sticking with me so long. Wire fraud alert. Please talk about wire fraud. This is an opportunity for you to say to your buyers, wire fraud is real. It is billions of dollars getting miswired. Do not wire money without contacting XYZ at XYZ Settlement Company. They will be in charge of you. Do not wire any money or give any wire instructions without talking on the phone to XYZ Closer, who I'm putting in charge of this file. I want you to talk on the phone with that person and receive the wire instructions, or that person says, I am sending the wire instructions via email right now. Confirm it, because wire fraud is happening way too much. And Rhonda was kind enough to share with us her experience. It can happen to anyone. Okay. And it was not even Rhonda's, Rhonda didn't create it to happen, but it's happening a lot. So please just take an extra step of caution there. Seller representations, sellers warranting that they own the property and they're the only person who possesses an ownership interest in the property. And that's it, y'all. Whew. Okay. I'm gonna tell you, 20 years into this, if I have a first-time home buyer and we're writing an offer for the first time, it's going to take me almost 2 hours. But I'm going to tell you what, my buyers are going to know every step of that contract. They're going to have confidence with what they're signing. And when I start talking about things like inspection timelines and business days and appraisals, they already know what I'm talking about, or at least it's going to sound familiar to them. Okay. When I start talking about mechanics liens or receipts, that is an investment I'm willing to put into buyers. Now I do tell them, hey guys, if we don't get this one, I promise this will be easier next time, because you're already going to know what it all says. So just like I'm explaining it at length to you guys, I'm doing that with my buyers. I really am. I am never sending new buyers something to sign that I have not walked them all the way through. The only reason why I can explain it quickly like that or summarize each clause is just because I've gotten down in there and I've tried to understand them and explain them so many times. It'll become easier and easier to go through those clauses and summarize the clauses the more times you do it. So I'm going to stop recording and open it up to questions.